Can be permitted to mention.
Give all order 41.
No order. Good.
Give all order 41. Please give all order 41. Give all the applications, please.
Application in
All applications, any kind of application.
application
Review,
restoration.
contempt, restoration, recalling, clarification, modification, whatever, give.
Application.
1 minute. Just wait for. Are you in hurry?
No.
No, just wait for 1 minute. Let us go. Give all the extension of interim order. Yes, miscellaneous appeal, or give all the hearing matters. Give.
Matrimonial.
All hearing matters. Who has given this WPCT?
My lord,
I don't have a determination.
order you have had the matter, my lord. Your lordship reserve the order, my lord.
CAB, then it will be done. Don't worry.
My lord,
Yes.
your lordship had the matter.
Yes, it will be done. Don't worry.
Milord, with kind leave of Honorable Justice Milord, Prosenjit Vishwas Milord, may I make a medicine, Milord, before your Lordship, Honorable Justice Harish Tandon. Milord, sitting with your Lordship, Milord, Honorable Justice Sampad Otpal, Milord, two matters, one was decided by your Lordships, Milord, and other one contempt and review application. Let it appear before your Lordship. When then I shall mention there.
Let us see when.
Lordship, kindly give a chance to the petitioners, Milord.
দেখে নাও ওনার সঙ্গে কবে বেঞ্চটা করতে পারি কন্টেম্পটা রিভিউ আছে
My lord, with the leave of the my lord Justice Prosenjit Banerjee, my lord, I find
Again, too deeply obliged to you, Lord.
application, contempt application, my lord, they had by my
why
lord
you are
Justice-
mentioning I said
My lord,
please give.
my lord Justice and Justice Obindranath Samanto, my lord.
Please now then you'll have to go to the honorable chief
No, my lord,
no
that is
it
the
can be done, it
notification.
can be done. Give.
Notification.
Yes, give.
Lordship, may I beg to mention, Lordship, item number 27, Lordship, I am for the capital. Lordship, I am praying not this week because Mr. Chatterjee learned.
Order 41 you have no right till it is admitted.
Lordship, he is not coming court, Lordship, you are.
Madam, you don't have a right before the admission. We can dismiss at the admission stage. Wait.
Lordship,
My
Wait.
lord,
Next call.
my lord, that I have given one FMAT application. My lord, the thing is that this matter was earlier listed before Justice I.P. Mukherjee.
এটা
but-
ফেরত দিয়ে দাও। Give back, which is one, it will be returned to you. When we said that hand over the slip, what is the necessity of mentioning? Why you are mentioning orally?
Sorry, my lord.
We have accepted your slip.
Sorry, my lord.
What more?
Sorry, my lord.
Yes.
My lord, it is contempt application, my lord.
Yes.
Yes, my lord, I explained in my part.
What is this contempt? Where is the order?
My lord,
What was the direction?
Direction was, my lord, the kindly see page 14. Dispose of the writ petition without interfering with the order of the tribunal, but exceeding the time for disposal of the said appeal, which shall be done by the appellate authority within 1 month from the date of
Yes.
communication. of
When
this
the order was communicated?
Yes, my lord, the order was communicated on, my lord, 2nd December 2020.
Where do I get it?
My lord, yes, page, my lord, kindly see, page 11. Page 11,
Yes.
top, the authority affixing the office seal and signature.
Yes,
Now, my lord, I find the part compliance, my lord, how the conduct of the petitioner. My lord,
Yes, my
where
lord.
is that?
I have stated in paragraph, my lord.
Where is my time prayer? Kindly see. He annexed my attendance. Where is my time prayer? Application. I deny this statement, which against me. My Hajira is annexed. And no necessary for my extra documents, paucity of documents. 2 months time, I prayed for 2 months time. Well, if any application or 2 months time, they are maybe making of application, kindly give 2 months time urgent petition. Where is my application? All blames to me as an advocate, as first class court officer. My lord, I very much, my lord,
Then, my lord,
Who is the lawyer who appeared?
my lord, me also. I attend appeal court. Kindly see page, Hajira on page 26. I file Hajira, the authority annex. Page 26. File Hajira, the authority could not able to complete the hearing. Thereafter, my lord, kindly see. Next Hajira. And even if my argument sake, I accept, kindly see the date, fixing date, 2 months, after 2 months. He very much acknowledged that your lordships directed to dispose of the matter within 4 weeks. Kindly see first hearing date 6/4/2023. Thereafter 13/6/2023 after 2 months. Thereafter 13/9/2023. Even if for argument's sake, if I granted trade for time, the authority with full knowledge, kindly see paragraph, the authority knowledge.
What is your name? Good name.
Pradeep Kumar Mandal.
So you have filed a Hajira,
Yes, me, my lord.
and according to you, never prayed for time.
No. And there is no application. There is no making application for giving time.
My lord, first of all, my lord, we first, according to his address, my lord, we sent the notice, my lord. That notice was.
Mr. De,
I-
Mr. De, there was a laudable message which was given in the order that the appellate authority has to show some alacrity. He cannot keep the appeal pending for all time to come. And then we directed you, your client, means the LS contemner, to dispose of the matter within a period of 1 month from the date of the communication. Communication was done on 12th of December 2022. It appears that for the first time you issued a notice on 28th of December 2022. You fixed the date on 6th of January 2023. I can understand from 12, if the limitation is counted, then it will end sometimes
11.
in 11 or 12th of January. You fixed prior that notice. The matter, it appears that the notice which was sent by speed post returned with the insufficient address. You fixed the matter from January to March after 2 months. You could not fix the matter. On 16th of January, you again issued a notice that could not be served. Then you fixed the matter in the month of June. They appeared in the month of June. They filed a Hajira.
April.
Your contention was that since they asked for a time, twice they asked for a time to collate the papers. And thereafter, you have shifted the dates. Now the next date is fixed somewhere in September. Now, where is an alacrity which you have shown?
Please, my lord.
Where is an alacrity which you have shown? If they have come, you have collated the documents. We are giving you a time. We are fixing our date, next date within 5 days or 6 days.
That should be done, my lord. That's
6 days. You come. Even on that day, I'm again fixing the date on just immediately thereafter within a gap of 7 days. Please come. I can appreciate your conduct. Is this a conduct? When there is a timeline of 1 month, do you take the court for a ride? Orders are being flouted. Orders are being dealt with in this manner. Even a courts do not nowadays give a dates after 2 months or 3 months.
But that is my lord, tribunal.
What do you have experience in the High Court?
Yes, my lord.
Today you ask for a time. We say when you are ready. You say 2 days thereafter. Are we not fixing a matter 2 days thereafter? You say for 7 days. Are we not fixing a matter after 7 days?
Yes, my lord.
Then why the authority would show such kind of a conduct before us? As if
My lord, I
he
want-
shows that he's so busy. He's so busy with this, he doesn't care the order of the court.
My lord, I am very sorry, my lord. I pay unconditional apology. my
What
lord.
is this going on?
On
Your
behalf of
conduct
the
itself is very bad.
client. Yes, my lord.
advocate
এক মিনিট দাঁড়াও না।
And secondly, we are not believing or disbelieving anybody.
My lord, we can.
He
My
is
lord,
the
you are not-
gentleman. He's an officer of the court.
Dispose of-
Please, Mr. De, he's an officer of the court.
Yes, my lord.
He himself went there. He himself had appeared. He says, I never asked for an adjournment. Now, tell me what to do.
My lord, I must, my lord.
It's a question of belief and
Yes,
disbelief.
my lord, I may
One
not want
has, one has to be believed, one has to be
to- my
disbelieved.
lord, I may not want
Why
to go into that.
So,
belief and
why-
disbelief. We have both of.
Why
us,
it is
my
not
lord,
done?
in a member of the bar association, my lord. So, my lord, I may not want to go in that. My lord, we fix one date, my lord.
How
that-
for?
that
If we
time-
have already, Mr. Day, if we have already fixed a date and a time limit,
on
and
my
if
prayer, my
this
lord,
time
that
limit
do
is
not-
being flouted in this manner, what do we expect from your client?
Yes, my lord. And on my.
Do
prayer, my lord,
do you make us to believe that he will do it?
Yes, my lord,
We do not.
my lord,
We have lost
my
confidence.
lord, no, my lord, I pray, my lord.
We have
as
lost
my-
confidence.
As I am the advocate, my lord, I pray, my lord, I must do it, my lord, within 7
No,
days,
no.
my lord.
It is not you, sir. You are representing an LS contemner.
Yes,
It
my
is a contemner who is an appellate authority. He has to comply the order.
Yes, my lord.
You can't have a control over your client, whether he will do it within 7 days. You yourself can do it. I have all believe in you that if Mr. Day says 7 days, he will do it within 7 days. But how can you control him? Do you have any controlling powers over them? He will again do it.
No, my lord, I must.
He will again do it
I can-
because the past
can
conduct
monitor
is
it
very bad.
Personally, my lord, in that matter, I pray 1 month time, my lord, or when your lordship pass that order.
So that is what we expect. We respected that.
Yes, my lord.
That
That is, my lord, I pray, my lord, 7 days time, within 7 days, my lord, he will go a date fixed, my lord, he will. go there.
no, definitely. This is not the way. Has he appeared personally?
My lord.
No, his conduct is, we are,
I,
because he did not appear after the notice is concerned. We have to issue a rule, ultimately compelled to issue a rule. And now when the rule has issued, we are simply hearing you on the quantum of the sentence. We are hearing you on the quantum of the sentence. What sentence we can give? Maximum is 6 months. Only thing is how minimum, whether we can reduce it from 6 months to a 1 month, or we will go for a maximum.
On behalf of my client, my lord, as.
Definitely not.
My
His
lord,
conduct
give
is
My lord,
not ready to do it.
me a chance
2 months,
Yes,
3
sir.
months time.
My
He's
lord,
giving
for that.
from June to September.
That-
What is the necessity?
for that, my lord, I pray, my lord, on my behalf, my lord.
Sorry, we can't.
My lord, your lordship can.
No.
My lord,
He's holding the service.
that is the additional district magistrate and district land and land reforms officer.
Yes, let him. Let
My lord,
us.
give me
Let
7 days
us.
time, my lord, we can
Let him
comply with the
there.
order, my lord.
Let him there.
My lord, because my lord,
There.
my
Your
lord,
affidavit itself is very clear.
Yes, my lord.
So we are just thinking of how much, what should be the quantum?
My lord, give me a 7 days time, my lord.
Should be the
I
quantum.
pray, my lord, I pray unconditional apology, my lord, on behalf of my client, my lord.
That you have not.
Yes, my.
That you have not. You have justified your conduct.
No, my lord.
And then you started saying that look at their conduct.
My lord, as per statement, my lord.
So I was just looking at it. Yes, if he has asked for an adjournment, I was with you. But when he came, he said, I am the person who appeared and I never asked for an adjournment. Then what?
My lord, give me a chance.
What
One
chance?
To me,
What
my lord,
chance?
not my client, my lord.
No.
That is, I personally on the, before that
No.
order was passed, my lord, I say, my lord.
That
within
is
1
why
month-
we passed. We know the difficulties of these administrative officers. They are really, burdened with lot of works. You said 1 month. We also accepted it. 1 month is quite a reasonable period. Do it. But this is how it happened.
On
This
my
conduct.
my lord, I know, my lord, the conduct is very.
Sorry.
In spite of that, my lord,
Sorry,
I
we
pray
can't.
before your lordship to give
No.
me a chance, my lord.
No,
As
definitely
because,
not.
my lord, I stand on behalf of my
No.
contemner, my lord. So, my lord, I pray, my lord, give me only 7 days time, my
No,
lord.
definitely
I-
not.
I never.
His conduct is reprimandable. His conduct is reprimandable.
Yes, my lord, that is, after hearing both of us, my lord.
This is not expected.
Yes, my
We can ask an affidavit from him. I mean, he will come say that I will not ask for an adjournment. Then what
I
will
may
what
not
will
want
happen?
to go, as because he is an advocate of our. my
So,
lord, my lord, I
Even if
can't
Malak Ali
want to-
direct him to produce a piece of documents that I adjourn I pray for time.
He has approached the court by filing a writ petitions. He has all the documents with him. What more documents one can collate? Require?
So my lord,
Well-
give me only 7 days time, my lord. My
Well,
lord,
sorry.
my lord, we fixed one date, my lord.
We are
on that
giving you a 7 days time, but there,
No, my lord,
there.
as because my lord, it is.
We are, for the time being, we are
I'm
giving a
going to,
7
my
days
lord,
time.
my lord,
Spend good time there.
my lord,
Better
give
to
me
spend time.
Only 7 days time, my lord, as
And that
both of
will be a
us is-
best place to introspect.
My lord, as both of us as advocate, my lord, for that is my lord. I give me only 7 days time. Only I pray, my lord.
7 days time,
No,
spend there.
my lord, give me
Spend
only.
there, come up,
My lord,
come
only
thereafter.
7 days time, my lord. I
Will give you another time to comply. Is there any other additional judicial this district magistrate?
No,
Yes, my lord, on the.
How
last
many?
of-
How many posts are there?
Oh, what a post.
SRL 2. My lord, on 13/6/2023, my lord, the.
I am asking you, he is a
একজন.
is an additional district magistrate and district land and land reforms officer. If he is an additional district magistrate, is there more than one additional district magistrate?
Yes, my lord, there are 5 additional district magistrates.
Correct,
Only
and
he is the land and land reforms officer.
correct.
Another is administration in several. according
No
to the-
difficulty. So it is an interchangeable. Another district magistrate can be empowered to act as a district land and land reforms officer. No difficulty. Of the same rank.
That is
That
the.
requires notification. I know. We'll take care of that. No difficulty.
My lord, your lordship, I pray, my lord.
Yes.
Kindly pardoning, my lord, I, on behalf of my client, my lord, I may not
No.
want to submit before your lordship.
No.
So only for this.
What is
reason,
this
my lord.
going on, Mr. De?
My lord,
No,
I
don't defend.
drafted this, my
Sir,
lord.
don't defend.
It is a
Don't
very-
defend such a
very
lackadaisical lackadaisical at
My lord,
the alleged contemners.
Yeah, I
Don't
drafted-
defend.
This
Sorry.
compliance, man. So my
That's
lord,
not a part compliant. Mere sending a notice will not do.
only for that is will give me.
And
only 7 days time.
kindly, I have seen twice you send the notice through speed post. Third time you said through personal or special messenger, whatever. If first notice came with the insufficient address, was it not your decision? Should be your decision to send it through a special message?
My lord, everything is bad, my lord. In
So-
spite of that, my lord, I pray.
My lord,
You just wanted to gain time. Your absolutely motive was to gain time, just to show at the pittance of the compliance. That's all.
I am very sorry, my lord, to tap this.
No.
Only
My
for
lord,
that is, my lord.
my lord,
give
I
time.
am also sorry when my learned friend said, stated that I drafted this petition. When he drafted, he should look to any piece of documents against another claim of the another advocate. He should have looked
So, my lord, I am
when he
very sorry
drafted
for-
this contempt petition, where any time.
No,
petition-
contempt petition is drafted by you.
No, contempt, this petition,
Affidavit.
compliant petition, this averment. Affidavit, sorry, my lord, affidavit.
So, my lord, I pray, my lord, unconditional, I follow. Only 7 days time, my lord. I do it, my lord, and come before your lordship to show that the order was compliant. Only 7 days time, my lord.
No.
My lord, give me 7 days time, my lord.
No, definitely.
My lord, otherwise, my lord.
No,
my
we'll
client-
grant you a time there, somewhere else. 7 days time.
No, my lord, that I,
That will be a very peaceful, calm,
My lord, he is a junior.
There's a lot
officer,
of
my lord.
time you will have to introspect.
No, my lord,
Everything you do it.
he's a junior officer, my lord. He is. So, my lord, I pray on behalf of him, my lord, before your lordship. I never, my lord, ask for this type of.
No, that's true, but look at
Yes, my lord, I know only for that reason, my lord. I say, I submit before your lordship that I adapted this petition. In spite of that, my lord, I pray unconditional apology on behalf of my client. I never. My lord, give me one chance, my lord, only. Nothing else, my lord. I may not come, my lord, on the. So give me a chance, my lord. Only 7 days time, my lord, your lordship. Oh, I must comply the order, my lord, within 7 days and must come before your lordship with compliance.
no,
My lord,
no.
give me, my lord.
It will percolate a very wrong signal in the society.
No, my lord. Yes, my lord.
If
Yes,
the
my-
officers
my lord, I-
are exonerated
Yes, my lord.
in this fashion, that it will give a very wrong signal.
My lord, that is.
Nobody would care about the order of the court. Nobody would think of,
For that.
because they think that I can get away with this
I am.
from a contempt.
For the
jurisdiction.
conduct
No.
of my conduct. That I should not draft this type of. In spite of that, my lord, I pay a junior officer, my lord. I stand.
So why you draft it?
Yes, my lord.
Why you draft it?
As per their.
Mr.
I
Dey,
annex all
suppose if there was anything which was standing in the way of completing the entire exercise within a time limit, you could have make an application seeking extension of time.
Yes, ma'am. That is.
You
the
did
possible-
not. You did not. That look, 1 month time, I've sent, the matter has come up. They would appear with this. We would have fixed a date here and now and tell them to accept the notice in the court itself so that he will go and appear.
Yes, ma'am.
You did not ask for a time. You just thought of, oh, 1 month is immaterial. It is of no consequences. The court invariably fixed the time limit. We are not going to adhere that time limit. That's the approach which appears to us. Then absolutely fixing a time limit of disposal is a farcical approach by the court. The court should not do it. Why will put a time limit? Why? No necessity, because the authority will proceed in his own way, either at a pace of a turtle or a tortoise. I do not know.
My lord, that is. My lord,
They will
My lord, I undertake before your lordship that
not undertake.
give me, my lord, only 7 days time, my lord. Otherwise, my lord, I can't. My lord, before your lordship, I never come with that fashion, my lord, that it is my wrong, my lord. That is only for the cause of my wrong, my lord. That is.
No, you're not. You're wrong. What are you talking about, Mr. Dey?
Yes, my
You're
lord.
not at fault.
Because, my lord, I should see whether that language of the contemner is, my lord, is totally with the. Only for that reason, my lord, I give me only.
No, it is not a language. It is a conduct which is reflected,
Reflected by my-
from this particular affidavit.
Yes, my lord.
It's a conduct which is reflective of an apathy, is a reflective of a dormant attitude. It is a reflection of, I would say, non-compliance of the court's order. That's the reflection. What more?
For that reason, my lord, give me some time. My lord, only 7 days. My lord, I must come with compliance report within 7 days. My lord, give me. Otherwise, my
No, we'll
lord,
give you time, but somewhere
lord,
else. Somewhere
my
else.
lord,
And we will be making a direction upon the state government to put any kind of a notification or authorizing another additional district magistrate
my
to
lord,
act
he
as
is a
the
very
land
junior,
reforms officer.
Here officer, my lord,
He will act as a, you need not have to do it.
my lord,
You have a paucity of time. You are burdened with lot of administrative work. These are all menial works which you do not want to do it.
my lord, no,
The
my lord,
fringe works, why you will do it?
my lord, give me
Don't do that.
My lord, give me on
Don't do that.
only 7 days time, my lord, I must comply the, my lord, due to the cause of myself, my lord, I am very sorry that I stand for this type of, in spite of that, my lord, I pay 7 days time. my lord.
Mr. Dey, your
Yes, my lord.
persuasive appearance
My lord.
is well appreciated, but still one has to look at the law. One has to look at the,
I am always in favor of this, that,
Oh.
my lord, that our institution should be always in the, but that is, my lord, give me only 7 days time, my lord. I must contact my lord and comply the order, my lord, within 7 days. My lord, your lordship, give me 7 days time. My lord, I must come with the compliance report, my
I
lord.
do not know my brother's view, but I am firm.
My lord, give me only 7 days. See,
Now my brother has also joined with me.
as because my lord, as my lord, that is a very junior officer and my lord, give me some protection.
He's a
Only
junior-
for that. my lord.
Since how long he is discharging this function of the land reforms and land reforms officer? Since how long?
3.5 years.
So by this time, one is well groomed. 3.5 years is quite a sufficient time to groom, to understand. And if he has, I do not know, this is the first instance that has come before us.
This is the first time, my
There
lord,
may be multiple instances because he's a very responsible officer. He is an appellate authority under section 54.
Yes, my lord.
And there must be I think, up to numbers of the appeals which are, how many appeals are pending before you? Can you swear an affidavit that since that is the earliest appeal of which year, which is pending before you? And give the total number of appeals from the earliest,
From his joint, date of joint.
even before that. Give. Since when these appeals are pending?
Yes, my lord.
And we find that these are the things which is going on.
And within 7 days, my lord, I can comply. And I pass
No.
compliance report, my lord,
No,
along with that report.
oh, lot of appeals. Show us how many appeals are pending before you.
My lord, we can-
Tomorrow, bring that register, bring everything that how many appeals are pending and since when these appeals are pending. We'll see to it.
Yes, my lord.
We'll see to it. Let us see your conduct.
Yes, my lord.
Which appeal gets more impetus and which appeals is still in a dormant stage. Let us see. Come,
Yes, sir.
Mr. Dey, on your request.
My lord, my
Give.
lord, register, I must
Give.
come with the
Give.
register. I must come with the register or everything.
That's the register of filing and the register containing the order of disposal as well.
Yes.
There must be a register maintained. Or if you are maintaining on a software, download it, duly certified by a computer, a person who have fed and who have extracted this from the computer. You will have to give a certificate under section 65B and C of the Evidence Act. He has to give a certificate.
Okay. Yes, ma'am.
And if we find that there are other appeals are pending, that means that shows that your conduct is like that. Yes, tomorrow?
Yes.
Not today. Come. And come with the, should I ask him to file an affidavit?
No, my lord, that is. My lord, he is an advocate, my lord, I have not.
That's why otherwise
That
I-
So, my lord, I cannot want that.
Let him come and say the truth, no difficulty. Let the contemner come and tell the truth, no difficulty. But shocking the responsibility by putting a blame on another shoulder is, we will not permit.
My
We
lord,
will not
it is a-
permit.
My lord, it is an open court, my lord, I may not want to submit everything in the open court, my lord. I am very sorry, my lord. As an advocate, not an advocate, my lord, I was the secretary of the bar, my lord. So I know. So my lord, my first predicament is member of the bar, not the others. Sorry, my lord.
Yes, my lord. Lordship, I am for the appellant pursuant to your lordship direction, I
appear for the Eastern Coalfields.
Yes, my lord, I am very sorry to say, your lordship, some amount of maintenance has been paid, lordship. Out of 2,16,000, lordship, they 40,000 and odd has been paid by ECL.
My lord,
Why you are not paying?
I am for the appeal. I
I
am
appear
for
for
the
the
appellant. Wife
Eastern
is the
Coalfields.
appellant.
Oh,
Wife is the
why?
appellant.
My lord, it's not that we are paying, my lord, because my kindly take up the order dated 24th of January 2023.
1/3 salary has been attached.
Whatever his salary would be, my lord, we will deduct 1/3 and
Which one?
order of 24th January 2023. This was the first order, my lord.
Anyhow, so 1/3 was remitted. Now, after this January,
Lordship,
so
initial order.
it's a February, March, April, May, June.
Lordship, initial order 28 September 2020.
That I've seen.
Lakhs and
16,000, I
Yes.
understand.
Out of that, Lordship, 40,606 has been paid.
That includes an attachment.
Yes.
That includes an attachment of the salary as well.
This is Lordship, as per Lordship order
Only the
dated,
salary, ma'am.
only the
It's
salary.
What my learned friend is
1/3
trying to
salary
say.
has been attached.
Correct. You say that out of 2,16,000, you have been paid 40,000 and not.
Odd, Lordship.
I am simply asking you, madam, that whether this 40,000 and not includes that 1/3 salary is that also,
Lordship, I am very sorry.
or it is otherwise than that.
lord, so far,
That
why-
I cannot say, Lordship.
Cannot say. Then what for you are here?
But it was deposited to my account, 40,000 and odd.
Till when?
On 25th May 2023.
So that
paid
includes the attachment amount as well.
Yes, that is true.
That's the only
11,000
attachment amount, my lord. That's the attachment amount only.
I think
I
it may be,
suppose, my lord,
it may be that is
It's not-
attachment.
Why
amount.
you will not pay the rest?
no, my lord, as per the order we are paying, each month we are deducting and we are crediting. Each month we are deducting and crediting.
1/3.
Yes.
We are enhancing it to 3/4.
From,
I have
from
nothing to say,
December,
my lord.
from December 22, we did.
We are enhancing from 1/3 to 3/4.
133.
3/4. Means 75%. Attachments, it will go.
1/3 attached to it. From December 22, and further amount is due, Lordship.
Oh, my lord, what happened in this matter, my lord, she didn't submit her particulars.
And these are the particulars. I mean, these are- what is it? I'm getting over.
Is it still working?
Yes,
Yes, my lord.
he joined. He was absent for a long time. He was discharged. Charge sheets were submitted. Then on the prayer of the husband, he joined. My lord, he filed an application for recalling. In the application for recalling, there
kindly
are
take
some
up the
documents
second order.
attached by my learned friend.
Very kindly take
Can
up the
four-
second order,
Can 4 of
17th of
Who is,
2020.
who is representing the ECL?
ECL, my lord, I am representing, my lord.
You are ECL, you
Yes.
are O. Who is representing the husband?
No,
No one is-
I just thought that you are
No, my lord,
representing
I
the
am-
husband.
on the earlier petition-
I was under the impression that you are appearing for husband.
No, my lord, I am
Lordship-
ECL, my lord.
My reaction came because of that.
ECL, my lord. I
Lordship,
appear for the
what
ECL.
happened?
Husband is also 1 minute, my lord. Husband is also not appearing. So far, I have understood from her submissions and from her pleadings, my lord. Now I appeared pursuant to the directions of this honorable court. Thereafter, my lord, that order of January 2023 was passed. My lord, second order was passed on 17th of April 2023. Pursuant to the direction of this honorable court, my lord, I had already issued the letters to the husband, and also I had written to her advocate on record, the official address which was written by me or which is with me in my record, my lord. Thereafter, my presence was dispensed
The
for the
husband
time.
never appeared.
Yes, on 28th September 2020.
Thereafter.
That
To
once
who appeared for him?
he is the junior of Dinesh
Arijit
Singh.
Bose.
Yes, he is the junior of Mr. Dinesh Singh. Dinesh Singh is general.
Pursuant to the order, we are deducting every month, my lord, 1/3.
This is-
How much he is getting per month?
My lord, he's a time-rated worker, my lord. If he
Time
if he is-
rated stone
if he is-
stone throwing manager.
and he's an
time-rated-
habitual absenteeism for which we
Mazdoor.
issued a charge sheet. After all, he remitted his, he came forward and mercy petition was made by him. So we again reinstated him because, and basically we.
How much he is getting per month?
My lord, there is an application filed by me for recalling, my lord, can 4, probably it's not. there,
Why
but
you will ask for a recall?
No, recalling is over, my lord. That
He
petition
asked
is
for
disposed.
recalling the order.
Why?
Follow.
Well, no, my lord, personal manager was summoned, my lord, to appear personally, the ECL's personal manager. So I prayed for I made an application for recalling, my lord. That matter has already been disposed of. My lord,
No,
here,
how
my
much he
lord,
is getting? How much he is getting?
getting, my lord, per month, it's not the same.
Average?
Average is, my lord, it's, may I, just a minute, my lord.
When he filed the recalling application,
What?
1 minute. Gross, permission gross. My lord, 33,000 in 1 month, my lord. I'm seeing for 33,987.43. In 1 month, my lord, it's to 12,505 because he's an habitual absenteeism. Habitual absentee, my lord. So it varies, my lord. It's a time rated worker. So time rated, piece rated, my lord. There are several categories, my lord. So as per the sheet, my lord, it was for the November 2022, which I could get, my lord. So
Can you
whatever,
serve a notice on Mr. Arijit Bose?
my lord, he will not appear. I tried, Lordship, for several times, he will not appear. That is why I served the copy of the paper book by post through to the husband.
What is the decree for?
Decree for Lordship, divorce decree on the ground of cruelty and desertion
Granted,
granted,
you are challenging this.
Lordship. They failed to prove. And the marriage was not consummated, but they failed to prove. Marriage was, he He admitted in his cross-examination that my learned advocate written that marriage was not consummated.
But it was actually consummated.
Yes, he admitted. He admitted in his restitution of conjugal right. In cross-examination, he said
No, no, this is a decree for divorce or a decree for restitution?
decree for divorce
Divorce.
under section 13.
So where he admitted in a proceeding under,
In this suit, in this matrimonial suit,
you say restitution of conjugal rights. That's why I asked you. Why you
he said that in the restitution of conjugal right, I wrote that marriage was consummated, but in connection with the suit,
What
when
happened to that application for restitution of conjugal rights?
it was withdrawn. It
By-
was withdrawn
That was
by the
filed by
husband.
whom?
By the husband.
Husband. And then he withdrew. You appeared in that matter?
Yes, I filed written statement in that matter.
What do you do?
Nothing. I am a housewife. I have no source of income. I am staying in my father's house.
What do the father does?
Father retired person.
Government employee?
No, ECL employee. ECL employee, but
Oh, he was a ECL employee.
I do not know, my lord. I don't have that instruction when my learned friend is saying, my lord, must be. Yes. Drawing out the pension.
Where is the judgment? Which page?
no. It starts from 41 of my paper book.
Sorry for the timing. Last month, what was the amount he withdrew?
My lord, then I have to take that instruction.
You,
No, my lord, it was I read from my
Which
recalling
month?
application, the copy was with me.
what is the last?
November,
Can
my
you-
lord, it was
Can you,
November.
can you tell us the last month, how much he is withdrawn?
But last month means June 23, my lord.
Whatever.
But then I have to take instructions and to come back to your lordship. From January to June,
Actually, I am very sorry to say, November 22,
yes,
my lord, total salary
net pay.
Total salary 52,000 and odd.
My lord, net pay is on the left.
And
bottom.
when I filed the application for maintenance, he drawn the salary above 62,000.
My lord, whatever the salary might be, my lord, I will deduct 1/3. So far till date, the order is there. I will remit. My lord,
এই লোর কোড রেকর্ড এসছে, লোর কোড রেকর্ড এসছে এলসিআর।
It feels so English.
What is the point?
Lordship,
On appeal? In appeal, what is the point?
Lordship, kindly see the application filed by the husband. After filing the application, when I filed written statement, I have stated that 20th March 2013, Lordship, I was driven out. And then 22nd March 2013, when I went to my matrimonial house with my parents, I was not allowed to enter into my matrimonial house. This statement has not been stated in his application. After filing this written statement, he added in his chief examination in chief that yes, wife has come on 24th November 2012. She has come with his parents, with her parents, but her parents pressurized her to stay with me, but he denied. And then he adduced in his cross-examination that Lordship kindly comes at page 27 of my paper book that I have filed an application for restitution of conjugal rights before filing this case. It is mentioned in that application that our marriage has been consummated. Another Lordship in page 28, at page 28, he said that my advocate wrote down our marriage was not consummated.
And what is your statement in the cross-examination?
Lordship, situation.
Don't go by a husband's statement, your statement.
Lordship, situation compelled her to make such statement, Lordship.
Situation in the
She was
evidence.
tortured
She
in
said-
ill manner.
She said in the cross-examination that since the date of marriage, we never established any relationship of husband and wife. What does it mean?
Lordship, situation compelled her to make such statement, Lordship.
What
He
are you
was
talking?
tortured.
What situation compelled her?
He was tortured, tortured physically and
But
mentally.
before the court, you came and deposed. That situation compelled her to say this.
But he was tortured physically
was-
and mentally, Lordship.
Really?
He was denied to provide food and clothes. And
Madam, we are talking about the evidence which she gave in the court. I can understand that any statement made while she was there in a matrimonial relationship. There was a constant pressure on her. There was a torture on her. There was a threat of life on her. She may say something. You are deposing in the court, free to say anything. Why you said so?
Lordship, I am very sorry to say, Lordship, he cannot understand the statement, Lordship.
Sorry, I thought of that. That's why I asked for the lower court record,
Yes,
just
yes.
to consult the original document.
Yes, I have
It
seen.
is
Lordship.
there.
I have seen.
It is there.
I have
If you
seen.
have admitted it, then what remains?
Lordship, she was tortured, he was driven out, and the husband never went to his in-laws' house to bring back the wife. Never. He never.
Sir,
And-
his allegation was that after the marriage, you refused to cohabit with a two should go in camera. is not represented. But after looking into the
Before your lordship, my lord, by your lordship, my lord, the paper
এটা
book which has
কোনটা
been
হয়েছিল আগেরটা ইয়েস ও তবে তো ওটা নেক্সট থার্সডে হবে ওদেরকে চলে গেছে ঠিক আছে মঙ্গলবারই রাখো
my lord, so many documents has been annexed with this paper book, but my lord, I could not my lord, read this, my lord, because my lord, it is in the
You will also not
vernacular
read
and
that.
my lord,
You will also not read that, don't worry.
your lordship will also not read that. My lord, suit for partition, against the preliminary decree, the appeal has been preferred.
Why you say it's
No,
a,
but-
are you denying the right of the plaintiff
My lord, the
that he has no
no,
right in
not that the
its entirety
no, not its entirety.
or you are disputing the share?
Share. Now, my lord, I am disputing the
What the
share.
court has held,
The court has held that the
Plaintiff
plaintiff has the share to the extent that has been paid for in the
what extent?
that is, my lord, plaintiff has, my lord, 1.26 acres on the basis of 2 deeds that has been held. And so far as the other
What is the total property?
total property is, my lord, that has not been stated anywhere. What are the
Okay, what
total?
are you talking? 1.26 acres in a
Now, my lord,
joint.
kindly come to the plaint at page 23. My lord, so far as the share of the plaintiff that has been declared, so far as the share of the defendant is concerned, my lord, that has not been stated.
For that, the decree would go. There may be multiple preliminary decree.
Because, my lord,
You
there are
make an
total,
application
my
before
lord,
the
total
court.
19 defendants
Court
are
will also proceed and declare you.
total 19 defendants are there.
So what?
No matter the court said the accepting the property which is of the plaintiff, the others are of the defendants. So, my lord, so my lord, the exact share of the defendants until when will
you
go to
go
the-
and make an application there. Sir, you are aware a partition suit has a unique feature.
yes.
There can be more than one.
More than one preliminary
No
decree.
difficult.
No,
You
yes.
can approach the court
No,
and
my
say
lord,
that
the-
amongst the defendant, please declare my share.
But the court, my lord,
Oh, share. No
Well,
difficulty.
the-
Why for appeal?
my lord, the
If you
court-
cannot deny the plaintiff's right.
No, my lord, so far as some portions of the, not its entirety, so far as the some portions of the share of the plaintiff is concerned, we have denied in the written statement.
What deny?
Now, my lord,
Concentrate your point on the share of the plaintiff.
yes.
Don't take a plea that defendant share has not been declared. You can make an application, the court will declare. Decide it.
My lord, there are several transfer of the property. My lord, as many as, my lord, 11 deeds, the properties were transferred. Now, my lord, the deeds which was annexed in this paper book, my lord, I could not, my lord, go through that because my lord, it is illegible and, my lord, the documents is in vernacular in these sorts of, my lord, I could not go through these. I asked my junior to produce the certified copy, but, my lord, she is suffering fever. She has not come to court today. My lord,
A lower court record টা দাও। LCR টা নেই? বলছে। Where is Mr. Salahuddin Ahmed? He is appearing for respondent number 1.
না জিজ্ঞেস করছি কোথায় কিচ্ছু মনে হয় না।
Application has been filed for restoration.
My lord,
Any application for restoration has been filed?
of restoring this appeal. I was. Junior is also not here, my lord. And kindly permit me to go through the records.
Okay. No, I'm just ওই জিজ্ঞেস করছি। এটা অ্যালাউ হয়নি এখনো ডিসপোজাল? না 28/3 পর 4/7 অর্ডার পাচ্ছি। 4/7 অর্ডারে না নেই, কিছু নেই, এর মাঝখানে কোনো অর্ডার নেই। 28/3 পর কোনো অর্ডার পাচ্ছি না। নেই, আর শুধু 4/7 অর্ডার। তার আগে তো কোনো অর্ডার নেই। This is an application for restoration.
Kindly permit me to
You know, it's ready. এটা restored হয়। Call the next matter in the meantime.
My lord, this is my appeal, my lord, arising from a preliminary decree passed in a partition suit in 2015.
What are you
Learned
challenging?
judge, the learned judge, my father, we were six sisters and 2 brothers. I am the eldest son. Father, by a deed of settlement in 92, because of the conduct of the younger son, gave the property to me and an unmarried daughter, excluding the younger son and the other daughter. They are all parties to the family settlement. Now, in the lower court, the court construed, I must candidly say, arguments was advanced, misconceived arguments on my behalf, stating that it was a deed of gift. Lower court went into that question and said nothing, that is not a deed of gift, but it's really a family settlement which is binding. Now, today, the only difficulty that family settlement is in Bengali, I've given it for translation because your lordship, I cannot, my lord, I am a Bengali medium student, but this legal finer points I've given it for, it's not come. I was not well and the ladies also. So, but
Lordship,
I can read it. My
Lordship,
brother can
in
read
this,
it. No difficulty.
Lordship, in this matter, Lordship, I appear for respondent number 1, Lordship. The advocate on record, his mother is admitted to hospital. Lordship, kindly adjourn for 2 weeks. Lordship.
Who is
Advocate on record, mother is ill and he,
what is his name?
Devlina Lahiri is appearing for Devlina Lahiri is appearing for the matter. Lordship, for respondent number 1, Lordship, his mother is admitted in hospital. Lordship, kindly adjourn for 2 weeks. Lordship, and kindly fix any date in August.
Yes.
on
That
this
is a
ground, my
difficulty.
lord, I
That is a
cannot
difficulty.
accept.
It is,
Kindly,
it
Lordship,
is submitted
in-
on behalf of the respondent number 1 that the advocate on record of the respondent number 1 is indisposed as his mother is hospitalized. The aforesaid prayer has not been disputed, has not been consented by the counsel for the appellate. No, কেটে দাও. The counsel for the appellant submits. The matter may be taken up after 2 weeks. As in the meantime, certain documents in vernacular language are required to be translated in English to have a better understanding of the language employed therein, as the points relating to the construction of the said document is involved in the instrument. In view of the above, since both the counsels prayed for time, let this matter be listed after 2 weeks.
Great. Bonded.
Yes,
I beg to appear for the appellant, my lord.
where is the respondent?
My lord, I just had a talk with him, my lord. He's coming, my lord. On the last occasion, this appeal was taken up. My lord, this appeal arises from a judgment and decree, preliminary decree passed in favor of the plaintiff respondent. Against that, I have come up before your lordship.
Are you disputing his right title and interest or are disputing the
I am
share?
disputing his entire right, title, and interest over the property. Now, my lord, I have prepared a short written notes of argument, my lord, to cut short the matter, my lord. I just place it with your lordship. Your lordship, no, Tada no. Your lordship would kindly take internal page 2 of the written notes of argument. My lord, this written notes of argument, my lord, this has been given in a tabular form, my lord, to which portion I have admitted and which I have disputed. My lord, what is their plain case? My lord has found
Kartik Maji, Ajoy Maji and
Abhay Maji and
is the
Gopal
joint
Maji
owner.
were joint owners to the extent of 1/3 share, that is Panchana, Choganda, Tugora, Dukranti of the suit property. Gopal, who was a bachelor, died intestate. Thus, his share devolved upon his two brothers, that is Kartik and Abhay.
Defendant
Therefore,
has
Kartik-
admitted the fact.
I have admitted this fact. Thereafter, my lord, Khetro Maji and Mohendro Maji, they are my predecessor in interest. Where
They're a 2/3 owner, the other.
this has also been admitted. Now, as regards the, my lord, CS record of rights, this also has been admitted by me. Now, where the case in their cross-examination, they categorically admit that Rajendra does not have title to the property. I'll be placing
Who
that.
is Rajendra?
Rajendra is their predecessor in interest, their
Okay.
father.
So somebody, Rajendra came in between.
Their case was Kartik and Abhay transferred to Rajendra.
Oh, Rajendra, sorry. And from Rajendra, they got it.
Rajendra
You said that this Kartik and Abhay never transferred.
never transferred to land.
Then
As a result whereof, the subsequent deeds also goes. Now, in the entire trial, they failed to produce the title deed.
that title deed of
Rajendra.
Kartik and Abhay in favor of Rajendra.
Yes, they
Then-
failed to produce that.
Then
In their cross-examination, they categorically admit that Rajendra does not have title to it. I'll be placing that.
never had.
I'll be placing that, Manoj. Now,
this is the sum and substance of my case. And I make out another case. If in the RS record of rights, the share somehow has been mentioned of Rajendra. I say that it is an erroneous recording. And they have taken advantage of that erroneous recording. And the share depicted in the RS record of rights is much less. Had the plaintiff case been true, then it would have been depicted otherwise. That was also my defense case. Now, my lord, may I place the plaint and the written statement and the relevant evidence?
Then they did not produce any title deed. Then how the court arrived at the conclusion?
Yes, court has gone into the LR record of rights, took it as a sacrosanct and passed the decree.
Title based on LR record of rights. Where is that finding?
Title deed is there.
Just 1 minute. You need not have to. It's not a debate which is going on. Show us.
My lord, I'll be so far as the LR record, the court's finding.
Court's finding.
I'm placing.
66. Page 66.
Oh, he has stated in 100.
Yes, yes, yes. Yes, kindly take page 118. My lord has found 118.
Huh?
My lord has found page 118.
Hmm.
ROR is a record of rights and not a document of title. ROR just raises presumption in respect of title.
Oh.
My lord?
It never raises presumption in favor of the title.
That is what's the court's finding. Is considered to be correct and unless rebutted by cogent evidence. The cogent evidence in this respect is something contrary to the ROR. The plaintiff's side is bringing a deed of gift by a woman who transferred a property she claims to have been gifted by her husband to her. Such transfer is made to the wife and sons of the youngest son, while she has 4 sons, 6 daughters, and none has alleged the said deed from 1985 till 2008. There is no defense case that the other heirs of Shurodhani are necessary party to the suit who are not added as party. They too have never challenged the deed in any way or claimed any right over the suit property. The CSROR and the LRROR and the said deed together form stronger evidence against the exhibit A and B because these documents are not much reliable as against the plaintiff's brought evidence as discussed in exhibit A, that is the RSROR, in respect of Mongja Khukurdao Khotian 78 without the official seal of the issuing authority. Here, my lord, the court has come to a perverse finding. It has the official seal and the land revenue officials came on dock to produce the LR record of, to produce the RS record of. Your lordship.
Yes.
Proceed. Well, I'll be placing the plain, the written statement, and then the evidence, my lord. The relevant. Or then the cross-examination wherein he has admitted.
Show us that the deed of
Yes.
Abhay, Karthik and this
Kindly
was
take
not-
my list of
Abhay,
my lord, 2 documents my lord would find under page 3, serial number 3.
sorry.
These are the subsequent deeds.
These are Rajendra Majhi
Gifting to
executed.
Shurodhani, the mother. First deed, deed number 345 of 1969
Rajendra Majhi executed it, that 1/3 share to his wife.
to his wife. Now this deed is the exhibit 6A. Now exhibit 5A. This deed does not speak anything of how Rajendra acquired the property.
Okay. And then
And
Sudhara-
thereafter, the
Sudharani,
deed Sudharani gifted to my lord the plaintiffs. To the predecessor in interest of the plaintiffs.
Malati
Maloti,
Rani.
Maloti, Pulok, Olok.
Uh,
And thereafter,
They sold it to
they sold it
Narayan
to the,
Chandra.
yes,
Maji, the
Narayan
plaintiff.
Chandra, the plaintiff. Now, in all these three deeds, there is no whisper as to how Rajendra got that property.
Okay. So they never, till date, they have not produced that.
No, that was
And
never
but
produced.
now, you said in a plaint, they have said something in a defense
Yes, I'll please.
shows that plaint. That they recognize this share of
Yes,
the right of this Karthik, Avoy and Gopal.
yes. Kindly takes page 25. This is their plaint case.
Yes.
কত জেলা জরিপের রেকর্ড বিমার্জিন নালিশি ক তপশিল সম্পত্তির জন্য একটি বর্ণলিপি প্রদত্ত হইল তাহা আরজির একাংশে বলিয়া গণ্য হইবে। My lord, the tabular statement supports that.
No, which paragraph?
Paragraph 6. My lord,
So, গত জেলা
গত জেলা জরিপ
record
ডিস্ট্রিক্ট সেটেলমেন্ট
বিমর্জিত নালিশি
নালিশি ক তপশিল সম্পত্তির জন্য একটি বর্ণলিপি প্রদত্ত হইল
প্রদত্ত হইল
তাহা
তা-
আরজির একাংশ বলিয়া গণ্য হইবে।
Correct.
Thereafter, উপরোক্ত বর্ণনা চিত্র অনুসারে ইহা দৃষ্ট হয় যে কার্তিক মাঝি, অভয় মাঝি ও গোপাল মাঝি
একত্রে
একত্রে নালিশি ক তপশিল বর্ণিত সম্পত্তিতে 5 আনা 6 গন্ডা 2 কড়া 2 ক্রান্তি। My lord, I must say what is written here. This is a mistyping, my lord. I checked the LR the lower court records. It is 5 আনা 6 গন্ডা 2
অংশের
কড়া 2
বাবদ মালিকও দখলিকার থাকে।
অংশে বাবদ মালিক ধরিকার থাকে। পশ্চাতে গোপাল মাঝি অকৃতদার অবস্থায় ব্যাচেলার ডায়েট ব্যাচেলার পরলোকটি গমন করলে তাহা ত্যক্ত সম্পত্তি তদানীন্তন উত্তরাধিকার আইন বিধান মোতাবেক তাহা 2 ভ্রাতা কার্তিক ও অভয় সমান
So they
সমান
admitted. So they admitted this 3 persons.
Yes. And thereafter, my lord, এবং অভয় মাঝি 5 আনা 6 কড়া 2 ক্রান্তি বাবদ মালিক ও দখলিকার পশ্চাৎ উক্ত কার্তিক মাঝি ও অভয় মাঝি উভয় তাহাদের 1/3 শেয়ার অংশের সম্পত্তি জনৈক রাজেন্দ্রনাথ মাঝিকে উপযুক্ত মূল্য গ্রহণ করিয়া উপযুক্ত দলিল মূলে হস্তান্তর
Did not
করিয়া দেয়।
speak which deed or something, nothing.
Yes, never. They do not speak. Now, kindly takes what was the case in my written statement. That, my lord, 2 paragraphs are relevant. Kindly takes page 37.
Yes. আরজি
আরজি
ষষ্ঠ দফায় উক্ত সত্য নয়।
সত্য নহে
Then
বাকি আরজির সহিত যে মালিকানা সত্য দখলের ক্রম পরিবর্তন দর্শাইতেছে তাহা সম্পূর্ণ মিথ্যা সাজুসিক হইতেছে এবং প্রকৃত অবস্থার বিপরীত। উক্ত ক্রম পরিবর্তনে মালিক কার্তিক মাঝি ও অভয় মাঝির পর ক্রম পরিবর্তনে রাজেন্দ্র মাঝি যে 5 আনা 6 গন্ডা 2 কড়া 2 ক্রান্তি অংশ প্রাপ্ত হইয়াছে মর্মে দর্শানো হয়েছে তাহা সর্বৈধ মিথ্যা। কতরূপ ক্রম পরিবর্তন বা হস্তান্তরের বিষয়ে বাদী কোনরূপ হস্তান্তর দলিল বা উপযুক্ত দলিলাদি দর্শাইতে সক্ষম হয় নাই। Well, this I have disputed that he does not have title. Now kindly takes further, I'll be skipping over, kindly takes paragraph 20. অধীন বাদীগণ নিবেদন করে যে আরজির তপশিল বর্ণিত সম্পত্তি অধীন বাদীগণের পূর্বধারীগণ আমলের সত্ত্বীয় দখলি সম্পত্তি হইতেছে। তন্মর্মে গত জেলা জরিপ, দ্যাট ইজ ডিস্ট্রিক্ট সেটেলমেন্ট, অধীন বিবাদীগণের পূর্বধারীগণ নামে যথাযথভাবে রেকর্ড হইয়াছে, কিন্তু পরবর্তীকালে উক্ত নালিশি সম্পত্তি বাবদ সংশোধনী জরিপকালে আরএস রেকর্ড অধীন বিবাদীগণের পূর্বধারীগণের অজ্ঞতা ও অনর্ধানতার কারণে নালিশি সম্পত্তি বিয়ংদংশ নালিশি সম্পত্তির সহিত নিঃসত্ত্ববান ও সংশোধনী জনৈক রাজেন্দ্র নামে এক ভুয়ো ভ্রমাত্মক ও বেআইনি রেকর্ড হিয়া হইবার বিষয় অধীন বিবাদীগণ এক্ষণে অবগত হইয়াছে। After this filing of the suit, I came to know that in the RS of record of rights, there has been this erroneous recording. That was my defense case. And thereafter, my lord would find that I have disputed, since I have disputed the original title deed, all the subsequent deeds goes. That I have disputed. Now kindly takes my, I'll be just placing their cross-examination, what they have said. Kindly takes page 68 and 77 once. Page 68. Second sentence, I cannot say how Rajendra got the property. My lord has found. I do not get any deed of to that effect. So therefore it is admitted he is not aware how Rajendra got title. And second, he does not have the title deed. Thereafter, my lord, page 77. Page 77, PW4. Seventh line. I cannot say how my father got the property. Seventh line from top. My lord has found. Now, my lord, in a
This PW4,
son of
Rajendra.
Rajendra. Now, my lord, so far as it's a suit for partition, it is elementary that he has to
Come after recess.
That has been restored.
Which order?
19th April, and it was
To 2023.
After recess.
We derived title.
They also claimed,
Yes, they also claim.
they say that yes, 1/3 was Kartik Ovoy and the 2/3 was Khetro or Mohindro. No difficulty. You are claiming from Khetro and Mohindro.
And that is their plain case also. Yes.
You purchased from whom?
My lord, that my lord would find in my written statement. Kindly takes paragraph 41.
Of
I stand corrected, my lord, page 42, my lord. Paragraph 2.
this is
Pro-
a written statement.
Yes, written statement.
Yes.
Page 42 দেখো।
প্রকৃতপক্ষে
প্রকৃতপক্ষে নালিশি সম্পত্তি কথিত রাজেন্দ্র মাঝি কোনরূপ খরিদা সত্ত্ব বা কোনো সত্ত্ব বা দখল না থাকায় তাহার নিকট হইতে তৎপত্নী সুধারানী মাঝি কথিত দানপত্র দলিল মূলে নালিশি সম্পত্তির অংশপ্রাপ্ত হইবা উক্তি সম্পূর্ণ মিথ্যা ও বেআইনি হইতেছে এবং তাহা সম্পূর্ণ অবাস্তব ও কল্পিত হইতেছে। That is it. No, thereafter, my lord.
অধীন বাদীগণের বিবাদীগণের তদন্ত মতে অবগত হইতেছে যে উক্ত রাজেন্দ্র মাঝি তাহার
পত্নী নালিশি কোনো অংশ
আদ্য দান করেন নাই বা করিবার কোনো কারণ নাই। কারণ is always there.
my lord.
কারণ is always there.
My lord, I couldn't follow, my lord.
I am reading the next sentence. These are all where you have derived title.
My title. Kindly takes Uddar. আমাদের title. My lord, kindly takes page 41. Has found, my lord.
You have not made out your case.
No, I have made
Yeah.
up. I am stating. প্রকৃতপক্ষে বাদীর আর্জি নালিশি দাবি মতো নালিশি সম্পদে
paragraph?
রেকর্ডভুক্ত তালিকা কার্তিক মাঝি অভয় মাঝি উক্ত মাঝি কোনোভাবে হস্তান্তর করা নাই তাহা নামিত কোনরূপ দলিলাদি আদৌ হয় নাই উক্ত রাজেন্দ্র মানি। But I'll just listen.
These are all your denying.
I've made out my case, but I'll just.
Where is your case?
First line, আর্জি তপশিল বর্ণিত সম্পত্তি অধীন বাদীগণের পূর্বদিগণের আমলের সত্ত্বীয় দখলই সম্পত্তি হইতেছে by inheritance.
Where?
Paragraph 20, first line itself.
আর্জির তফসিল বর্ণিত সম্পত্তি
অধীন বাদীগণ, that is we. বিবাদীগণ, we.
পূর্বাধিকারী গণের
আমলের সক্রিয় দখলি সম্পত্তি হইতেছে।
হুম।
তন্মধ্যে উক্ত জেলা জরিপে অধীন বিবাদীগণের পূর্বাধিগণ নামে যথাযথভাবে রেকর্ড হইয়াছে our predecessor now, কিন্তু পরবর্তীকালে উক্ত নালিশি সম্পত্তি বাবদ সংশোধিত জরিপকালে অধীন বিবাদীগণের পূর্বাধিগণের অজ্ঞতা ও অনাধরণতার কারণে
are you claiming through Khetro and Mohindro?
Yes. Now kindly takes the CS record of rights once. Kindly takes the CS record of rights once. That my lord will find at page 17.
2/3 Khetro or এটা Mohindro?
Yes, kindly takes page 17 once. Exhibit A. This is the RSROR.
Page 17.
Yes, page 17. This is the RSROR.
Who will read that?
But I am placing one.
Who will read it?
My lord, may I place the lower court records, my lord?
The first বিবরণ or দখলকার. What is this?
To lower court records.
Come to the second column. Rayoti, Dongo,
My lord,
Rammaji, Shammaji, Pita Mohendra Maji. Who are you, Ram or Sham?
Ram Maji, Sham Maji,
Yes.
Pita Mohendra Maji. From whom? Then Haripada Maji. Then Khetro Maji, Rajendra Maji.
Rajendra Maji.
Yes. Now, my lord, all this here, my lord will find Rajendra Maji, it is recorded Chogonda Akkora. Now, if the plaintiff's case is to be believed, then Rajendra's share should have been 5 ana, 6 ganda, 2 kora, 2 kranti. Now, kindly takes the CS record of rights that I have admitted. Kindly takes page 1, part 2 of the paper book. Kartik Abhay Gopal
Kartik Abhay Gopal Maji. Pita
Gopal Maji,
Premchand Maji.
Premchand Maji, Angsho Soman. Thereafter, next my lord will kind.
Khetro Mohendra Maji. Pita Balaram.
Balaram Maji, Angsho
Angsho
Soman.
Saman.
We derive title from Khetro Mohendra Maji.
That is not there.
That is not disputed by them. We claim through inheritance.
Correct.
Now, kindly takes the documentary evidence, my lord, would the subsequent deeds. My lord, kindly takes page. Kindly takes the first deed, that is December 18, 1985, that my lord will find at page 11 of the paper book. Yes, it starts page 11. My lord, thereafter, the second page, page
I
12.
can't read.
What?
I can't read.
Or may I place the
No, even the handwriting I can't read.
but I'll be reading. May I read it for your lordship or not?
Read it.
It says, it simply states, my lord, the 7th line, Ukto 1959 সনে আমিও পারছি না রে the deed number that is being stated here. This deed relates to how the Sudharani received from Rajendra. Now they failed to produce this deed also. Their case in the cross-examination that they do not know how Rajendra got title. They further failed to.
The heirs of this, the original one, that's 2 persons. Kartik and Abhay, they are not made parties.
Yes, they are not made parties. They are original owners, and that is our admitted case is they were owners to the extent of 1/3, but title was never transferred to Rajendra.
Yes.
Thereafter, my lord, in this deed, one statement is there that 15 years before Rajendra died. 15 years before Rajendra died. Sudharani is saying, the vendor is saying. Therefore, it must have been 15 years prior to this date. The alleged deed has to be there, the 15 years before, where Rajendra got the property. How Rajendra got the property? Because
his death was 15 years. He might have got it during his lifetime.
yes, that is what I am saying.
Maybe 25, 30 years
Yes.
back, whatever.
Yes. And if the date is to be calculated 15 years, that my lord will find during the RS record of rights, when the RS record of rights was in operation. Now, my case in my written statement is that there has been this erroneous recording in the RS record of rights, which is taking advantage of. And this RS record of rights, had the title been really transferred, and if I have to believe the plaintiff's case to be true, then the share should have been much more than that has been erroneously stated also. That was also the case made out in my defense. But nevertheless,
you can't resile from your own admission, 2/3.
now
You cannot claim more than 2/3.
I am not claiming 2/3.
That's all.
And he has to make out a case that he has some semblance of right title of interest. Now, my lord knows the presumption under section 114 subsection G, my lord. If he
Section G or clause G.
clause
Adverse inference.
adverse inference.
So-
In the entire trial, he did not bring the deed.
That's your case only.
That's my case.
Let us
And-
hear him.
My lord,
Let us hear him.
my lord, I'll be just placing the finding of the trial court once, my lord, the finding of the trial, the erroneous.
So now I have seen the last paragraph of the finding of the trial. That how he has said that though the entry in the record of right is not a document of title, but it has a presumptive value on title. We have seen.
And that so far as when I said that he ought to have come up with his title, there is this finding of the court that kindly just my lord has seen that, but I'll just court says that all the challenge that has been taken by me is based on hearsay. Page 117 kindly takes. On the other hand, the defendant side makes a positive claim that no transfer was made in favor of Rajendra by Kartik, Abhay and Gopal, but with a twisted approach. The defendants claim that they have heard so. All the challenges the defendants made are based on hearsay. I don't know how this court has come to this finding. And that was it.
Yes.
This is the factual part, and
Wait, please, Your Lordship. Lordship takes page 25. 25 gives the chart. The 25 gives the chart.
Sir, very simple case. You have admitted that the Kartik, Abhay and the Gopal were admittedly the owners.
My lord.
Of 1/3 share.
My lord.
You have also admitted that Khetro and another one is Mohindro.
They were
2/3 owners.
2/3.
There is no dispute.
There is no dispute.
You are not claiming any title through Khetro or Mohindro.
No.
You are not.
No.
You are claiming title through Gopal, Abhay and Kartik.
That 1/3 share.
You have also said that Gopal was bachelor or unmarried. So upon his death, his share also automatically devolved upon his brothers. So naturally, the Kartik and Abhay become the owner of 1/3 share. According to you, the Kartik and Abhay, they sold the property to Rajendra. Rajendra acquired the property. Rajendra during his lifetime executed a deed of gift in favor of his wife, Sudharani. Sudharani got it. Sudharani thereafter sold the properties, gifted the properties to the three people. Ulok and all, everything. And 3 people sold the property to you. Now, he raises a question that so far as the Kartik and Abhay is concerned, they never sold the property. There was no deed executed at any point of time. You can't be the shareholder, co-sharer. Because in order to maintain a suit for partition, a person must establish that he's a co-sharer in respect of the undivided property. He says that Kartik and Abhay never executed. It was your duty to prove that the Kartik and Abhay actually sold the property to Rajendra. There is no document forthcoming. He says that when there is no existence of any document, the onus does not lie on him to prove it because he can't prove a non-existent thing. Can anybody prove a non-existent thing? No. Which is not in existence at all. You ought to have immediately placed the deed that this look, Kartik and Abhay has executed this in favor of the Rajendra. The moment you prove it, I think that kills their entire case. they will have no defense at all. No defense. How you have proved that?
May I, myself? Defendants do not have any right, derives any right title interest.
Why you implemented him as a co-sharer?
Defendants do
Sir,
not derive.
Sir, you have filed a suit for partition.
May I please, madam? Defendants have not claimed their rights through Karthik and Abhay.
No, they are not.
No.
No, they are not.
They, my lord,
So they cannot raise any objection
madam, may I?
regarding the co-sharership.
Madam, may I? It is admitted position that in the year 69, in the year 1969, Rajendra gifted his his share in the property to his wife.
Sir, Rani, no difficulty. He is not denying.
May I?
Rather, he has not admitted it. Only thing is, he also raised a question that you have not able to produce that deed of gift also.
But that deeds reference are there in the other deeds. The deeds reference is there in the other deeds. Madam. But what I failed to produce before the trial court was the deed of conveyance from Karthik and Abhay to Rajendra.
To Rajendra. Correct.
The latter
So-
part is being duly exhibited and proved.
If the foundation goes
No, madam, may I?
and the castle
Madam,
has to
understand,
go.
my lord, where my lord is coming from. But my lord, till date, neither Karthik nor Abhay nor their legal heirs have filed any claim against Rajendra or his legal heirs. I derived my title from Karthik and Abhay. Till date, Karthik and Abhay has not challenged my title. Since they have not challenged my title and I derive it from them, my deed I have shown from 1969. Let us say till 1969. I go up to 1969. I do not know the date when these two people transferred it to my predecessor's father. I do not know because I do not have the deed. But these two people have till date not challenged.
Sir, you brought the son of Rajendra as the fourth witness.
My lord,
The witness, the son says, I never heard that my father acquired the property. I never saw any documents, deed in possession of my father. I never know.
no, man, may I place his cross-examination?
Yes.
Madam, may I please?
PW4.
PW4's cross-examination. Just give me a moment. Madam. Page 77. May I please? My house is a distance 5 bighas from the suit plot. My Vastu plot is so and so. I do not know Karthik Abhay of our village.
That goes against one take of the.
Well, may I place the evidence? Madam? My house is a distance of so and so. My Vastu plot is so and so. I do not know Karthik and Alok and Abhay. Plaintiff purchased the suit from Alok, Pulak and Maluti, who are my son and wife.
Who?
Plaintiff purchased the suit property from Alok, Pulak and Maluti, who are my sons and wife. So he is the son of Sudharani and Rajendra. PW4 is son of Sudharani and Rajendra.
No, Rajendra. He's the son of
My
Rajendra.
place. My two sons' wife got the property from Sudharani by way of gift. Sudharani got the property from my father Rajendra since deceased.
Correct.
I cannot say what he says. I cannot say how my father got the property.
This is what is very, very
I
interesting.
never saw any deed relating to the property.
This is also very interesting.
He says that I do not know how my
He does not know that
property was given to father to mother. He says he is here to say that my wife has got the property from my mother and sold it to these people. And now my lord will come to the defense cross-examination. Page 90. I never saw, third paragraph. I never saw Rajendra Kartik Abhay. I heard from my neighbors that Rajendra did get the share from Kartik and Abhay. Now then says I heard from my agnetic brother. He is aware of the fact. And then my lord, 2 pages later, 93. And I have heard from neighbors, Rajendra was never in possession of any portion. But this is his admission.
Where is the admission?
Kindly take page 90. Cross-examination. Well, may I please?
Yes.
I have gone through the plaint. The predecessor of Kartik, Gopal Abhay had 1/3. Predecessor of Khetro and Mohendra got 2/3. I know Gopal died a bachelor. Kartik and Abhay inherited the share of Gopal. Rajendra did not get any share of Kartik and Abhay. Not a fact, Rajendra acquired property from Kartik and Abhay. But then, I never saw Rajendra, Kartik and Abhay. I have heard from my neighbors that Rajendra Gotti is not there, get share of Kartik and Abhay. Then says, I have heard it from our agnetic brother.
What does it mean? What does it mean?
Yeah, he knows.
That is the hearsay evidence about the Rajendra's purchase. So it will go. Hearsay evidence will not be applied against him.
No, he knows that
He knows that he heard that somebody by the name of Rajendra has got the share of Abhay and Kartik. That's all. Heard. But he says, I don't believe.
But today before my lord or before any court of law, Kartik and Abhay is there. Who can challenge my title is Kartik and Abhay. But the challenge to my title can be done only by my higher.
He's a co-sharer. It is a partition suit. It is not a declaratory suit as you are arguing. It is not a declaratory suit, sir. It is a partition suit. You have brought the partition suit. What does it mean? That the entire property, be it 1/3 or a 2/3, if they are combined together, it's still a joint property, undivided. You wanted the separation of your share.
My lord.
So the moment you admit their right or you implead them, that means you admit that they are the co-sharer. And they have a semblance of right in respect of the joint property. So in your portion also they have the same right.
Everybody has right in everybody's share.
Everybody's share. So in that event, everybody's portion. So in that event, can he not as a co-sharer say that you are not a co-sharer, you can't maintain a suit against us?
But my lord, we derive title from my lord, we derive.
But you have to prove your title. You are claiming a co-sharership. He is denying your co-sharership. Will you not prove your co-sharership?
But my lord, Kartik and Abhay has not come before the court.
Not necessary.
And he have not challenged my title.
He can, whatever, I do not know. He could have pleaded the bat for non-gender or necessary party. He could have pleaded.
They have not.
They have not. It's still there. Will you not prove your own case?
But I admit to the fact that I do not have the deed.
So why you
I
did
do
not?
not produce the deed.
So you could not, even today at the time of hearing, you are not.
And my lord, what I say is in the record of rights.
Absolutely.
But in the record of rights,
that I have heard.
but in the record of rights, my name appear.
Not an admission by him. Not
But in the record of rights, my Rajendra's name appear.
Can it create a title? This is a bigger question. Show us one judgment. I know against you 1996 volume 6 SSC. I know against you 1997 volume 7 SSC. 2 judgments. First 2 judgments is known to me.
Record of right doesn't confer title.
Then-
I know that.
Then
But my lord,
the
presumption,
principle, the ratio of the judgment is that the entry in the record of right is not a determinant factor towards the title. Neither it can create title into a person, nor it can take away the title from that person. The moment you have to, you assert your title in the property, then you'll have to prove that title if the other side has disputed.
but can, my lord, my question, my lord, my short question before this.
You
honorable
can't
court-
take that who is he is not a declaratory suit.
Huh? Not what? No, ঠিক আছে, not. But we have claim declaration. Claim declaration.
No, that is a title suit. That's why I'm saying.
We have prayed for declaration.
No, declaration of a title and then separation of the shares.
Yes.
Means claiming as a co-sharer. The moment you, if it is a simpliciter suit for title, if a defendant comes and assert and he is not asserting any right title and interest in respect of the subject property, then I can understand. It's a composite suit.
As a composite suit, but
So,
we have claimed
in
for title.
really not, in every partition suit, there must be a declaration of the shares and the
Consequential partition by
the
Mixon.
separation of shares.
Partition by Mixon.
Straight away. So he has a right. You can't say that he can't raise the
But he
defense.
has not, but he has not taken his title from these two people.
Immaterial. Immaterial. In a partition suit, somebody is defending his title and he says that apart from me, there are other co-sharers. You have not
Then my
implemented
lord will give me
them.
some time to find
what
out the.
sometimes. Nothing.
I will try to
That's,
sort out
that's
the.
the only point. Very short point.
Short point is there. Let me
Sir.
try to fire.
No.
Ascertain the deed of conveyance.
No.
Give me 15 days.
How
time,
can we give you as a first appellate court? How can we grant you time like this? There is no document forthcoming. Nothing has come. We are at the stage of hearing of the appeal. What more?
But I have derived title from these two.
No,
people.
sir. We will say that you derive title. We will say that whether it is the title which really passed on or it is no title which passed on.
Let me give.
And whether you can maintain a suit for partition in this state.
Give
Nothing.
me 15 days time. Let me search out. Then my lord passes this. order.
Nothing. What can be? There is
If I
nothing.
can find my title deed, my lord, there is no case for that.
This suit was instituted when? 2008.
Yes.
Was it a original court or a transferred court?
No, original.
Original court. Then 2008, what you were doing? Nearly 15 years.
Give me 15 days. my lord.
15 years if you cannot, 15 days you will be.
I will try to find out. my lord.
Sorry,
My
you
case
can't.
lies in this, my lord.
15 years you just slept and now for 15 days you wanted to.
But let me find out my title.
No, it's not. There is nothing.
But
Rajendra's son has come and say, I do not know.
No, Rajendra's son, yes, he
Yes,
said.
he
So
says,
he-
I never saw that a deed. How can you get it within 15 days?
Let me search.
You
then-
brought him for some purpose, but that purpose could not be fulfilled.
But
No.
I have my share, my lord, in that property.
I do not know. We are still open, I am telling. Show us from the, whatever the pleading that you have proved. You derive title through Rajendra,
Fine.
whatever. Show us how Rajendra got it. Straightforward case.
Sir, we couldn't produce it.
Then
Give me 15
The
days
matter-
time. If I cannot
that's
find
to,
the deed,
the partition suit has to go. It has to go. You have not been able to prove.
my lord, kindly give me time. My lord, kindly gives me time, my lord, my entire case. My entire case stands on that deed, my lord. Kindly gives me some time to find the deed.
No, sir.
15 days, my lord.
No, sir.
If I am unable, my lord, kindly, because
No,
my entire.
unnecessarily you are delaying the
My lord,
disposal
I'm
of.
not- my lord, Kindly give me
Can't.
15 days.
Sorry.
If I can't search, I can't search, madam.
Is this? Sir, you are a counsel, you are arguing, you know that what you have to defend. They have been taking this particular plea from the day one when they filed the written
I know.
Then, and now you are asking for a time when we are just at the verge of the conclusion.
Kindly give.
No, sir. What for?
If I do not
What
find
the
the,
nation would say.
well, if I do not find the deed, I have no. My lord, I-
You had from 2008, when they filed the written statement, all the opportunity. Even before evidence, no difficulty. You had the complete freedom in that regard. Now,
Not
at
that
the
I cannot
appellate
improve,
stage,
but-
you know, the court cannot. There are very, very, very strict limitations for that.
রাজেন্দ্র রিসাইকেল দেখা না রাজেন্দ্র টিকটা দেখা দেখা বারবার করতে রিসাইকেলে কোথায় রাজেন্দ্র এরা দিয়েছে রাজেন্দ্র মাই লর্ড গিভস মি ওয়ান Give me.
Have you brought those line of judgment?
Yes. Your lordship would first the written notes of argument, so far as the presumption of the record of rights kindly takes AIR 1967, Calcutta, page 10, paragraph 12.
That is a presumption as to the correctness of the entry.
Yes,
Nothing more than that. Yes.
yes.
Then,
Thereafter, my lord, the plaintiff has to prove his own case, and that, my lord, will find 2014 volume 2 Supreme Court cases, page 269.
yes, 2000.
14
Yes.
volume 2 Supreme Court cases, page 269.
Yes.
My lord, relying on the judgment of AIR 1959 Supreme Court, page 31, paragraph 18. 15, 18.
Yes. Then,
And so far as the record of rights, which, my lord, the court has kindly takes paragraph 12, the next judgment, my lord, once 1967 Calcutta. The presumption of accuracy is a rule of evidence, my lord,
paragraph.
paragraph 12. 67 Calcutta.
Yes.
The presumption of accuracy is a rule of evidence. So far as the Evidence Act is concerned, section 4 and 114 of the Evidence Act deal with presumption. There are also other sections which we need not be troubled with in this appeal. Presumptions may be of fact or law, or maybe mixed question of fact and law. Here it is a presumption of law, which means only that law creates an artificial presumption, permitting the court to draw inference whenever the requisite facts as stated in the law are present. But it is at least a presumption and no more. The presumption of accuracy of the entry in the record of rights does not create or extinguish title, but only raises a presumption which again is not conclusive and can be rebutted by evidence. The presumption of law in favor of accuracy of the entry of the RS in the record of rights follows from the fact that such record is prepared after due publicity and notification and upon hearing objectors and interested parties. The entry in the record of rights made after such a procedure, therefore, is presumed to be correct until the contrary is proved by evidence. There cannot be, in my view, therefore, be any longer a presumption when the point in issue has already been decided. That goes into the question of res judicata. And the last three lines, my lord, if the civil court is satisfied on the evidence that the entry in the record of rights is erroneous, then it is for the civil court to say so, and it is only forum which can pronounce judgment on the correctness or otherwise of the entry of the record of rights. Judgment of Justice P.B. Mukherjee, madam. And, one more clarification, my lord. My learned senior friend was relying on the cross-examination. Probably, my lord, it was a mistake on our part. My lord, the paper book, there was a mistyping. It says, I have never saw Rajendra Maji, Kartik Maji, and Abhay Maji. I have heard from my neighbors that Rajendra Maji did not get any share. In the paper book, it is said did get any share, but it should actually did not get. I can place it. You're such a innovative. Page 2. Third paragraph. Dada, Dorita. It's got. It's very gaudy word. Not Hon'ble. Paragraph, page 2, did not get any share. Did not get.
This gaudy word has gone.
Yes.
It should be not. And when you pointed out to him, he said, forget,
No,
don't care.
No.
and I've seen that.
Yes, that's all. Thank you. Yes.
One more point, my lord. From 69, at least the date when Sudharani gifted to Rajendra gifted to Sudharani. No
I'm
challenge.
expecting what you will be saying. Yes.
No challenge.
So
Limitation statutory.
for every chain deeds, it has to be challenged separately if the parent deed is challenged. I'm asking you a very simple question.
But no challenge from the parent deed till
There is no difficulty why they will challenge it. If they say that all these deeds are on particular wrong assumption or whatever of the title, if the title never passed on, then why they will go and challenge it?
again I reiterate that the persons from whom Rajendra took has never challenged the title of Rajendra. Have never challenged the title of Rajendra.
The very big question is whether at all the Rajendra got it from that person.
But they have not challenged. Till date, there is no challenge.
If they may not be aware what is happening between two different individuals, how the third party will come to know that what is happening in respect of their
40
property.
years I am in possession of the land.
Now, this is what is something which we can't say. We do not know the nature of possession. We do not know anything.
For 30 years I am in possession of the land. I have been cross-examined that I am in possession.
And he admitted.
I have a furniture shop there.
You don't know in what capacity that is there.
But
Record of rights says something else. I do not know.
why not? I have been in continuous possession for more than 30 years.
Yes. So what do you want to say?
Since the owners have not challenged my title, I have
I'm asking you 30 years position. What does it mean?
adverse possession at best.
Automatic.
If I cannot show what adverse possession,
Automatic.
title was with these two persons.
I'm asking you automatic. a long position is automatically converted into an adverse position. Tell me, I will be happy to accept.
But the latest judgment says that adverse possession can be used to prove title.
No. Who says then what are the ingredients of adverse possession? I am asking you a simple question. Whether a mere long possession automatically converts into adverse possession.
Adverse possession,
I am
the
asking you a
test-
very simple
The
question.
test is, my lord, my title must be adverse to the title of the original owner. Must be adverse to the and that he has.
For that, what are the ingredients? What are the evidence which is to be proved?
That I am there for 12 years.
That is only.
And they have not taken any steps for eviction of mine.
That is the only one.
And my time and my possession is.
That's all. I'm surprised to accept this. No.
They are no one to this 1/3 share. They are no one to this. They have not even challenged this.
In order to assert the adverse position, there are the three legal maxims which has to be proved by you. Nec vi, nec clam, nec precarium. The position must be continuous, uninterrupted, and must be hostile to the original owner.
Yes, but that's what
And the declaration of hostility is a very important factor. When you declare yourself as a hostile owner, and that to the knowledge, mere continuance in position does not mean a hostile.
But they have
We have
not
to assert. No, sir, we can't.
These people have.
And
never-
there are judgments galore which says that mere long position in the property does not mean that it has converted into an adverse position. And you have not even taken a plea of anyhow. We will not go into it. It's an academic discussion. You have not
They
taken a
have
plea of
not
adverse
challenged-
position.
My
No.
1/3 share is there in the property, my lord.
Let us see whether it will be there.
Where do I go, my lord? I have 1/3 share in the property by purchase.
A is the owner of the property. C has purchased the property from B. C sold the property to D. D sold it to E. When E asserted the title against F, F says that no, you do not have the title. Because the original owner is A, never give it. The title is undisputed, never challenged. That's the very foundation of challenge.
So who challenges? Is my
Whoever, if you assert against F, F has a right to say. Don't assert against F. Because you have kept that A in dark. That what is happening between you and somebody else. They are in dark. How did they come to know that what is happening? And very interestingly, they have not taken a plea of non-joinder of necessary part.
They have also not brought in. Yes.
Whatever, they have not taken that plea. That ought to have been taken as a first.
Yes, joinder and non-joinder first.
Obvious. In a partition suit,
If they have not taken,
Co-sharer.
it, they admitted the fact that I have done.
title is admitted. Whether the title passed on admission
If they have not made their original co-sharers party,
or it is based, it should pass on through a document recognized in law.
document is not there before.
So,
Document is not there. I cannot improve upon that.
so that's why the
Possession
concept
admitted.
of collusive proceedings, the concept of fraud, the concept of the other.
My continuous possession admitted. I am there in the
Be
property.
there. Who
Admitted.
is going to disturb your position, sir? Enjoy. Continue enjoying. They are not asking to disturb your position. Who is disturbing your position? Nobody. Nobody. You are in position, they are not going to disturb.
I do not have the document. I have to.
So what more? Yeah, badly handled the case. When they took a defense, you ought to have brought
What
that
my
particular
junior
deed
says that,
straight away, and that would non-suit them.
what my junior says that 77 because of the 77 because of the flood, ADS are all records are got.
No, no.
He is from Midnapur, he is saying.
No.
I do not know, my lord. He has said me that.
No. Oh, no. Don't believe it.
And if not the certified copy, then book 1, book 4, those certified copies could have been taken. I know that one. That part I know. If the deed is not available, then book 1 certified copy where the entry is there, deed between this person and that person, that can be taken. That part I know. Even if the deed is missing, it can be proved otherwise that there was a
Some
transaction.
of the cases, even of 1930s document certified copies obtained in 2022 and then produced before us.
But he is,
From
what he is saying is
Midnapur.
from Midnapur,
From Midnapur.
76, 77 flood, lot of documents. But I'm not relying upon this.
Yes. No.
ये दे.
Yes.
My lord,
Thank you. Yes.
I brought on.
Concluded. Concluded. Could you put it up? Let's call the next. A. Sorry. A. এটাও রাখো
Like,
yes. What is this matter?
Plaintiff in a suit for partition suit dismissed for non-joinder of parties.
Wonderful.
I don't stop short there. The parties who were not arraigned as parties were added in the appeal.
Have been added.
Worship, I am appearing for respondent number
Got the order.
2B to G.
Succeeded in getting the addition. What to do? Remand.
My lord,
Worship,
what
we are
I would
agreeable to lordship partition.
Remand.
my lord, everyone
I
is
support the case of the plaintiff lordship in the court below.
You supported. Who
May I
resisted?
indicate? May I indicate, my lord?
Who resisted?
Resistance was by D1.
Yes.
D1 resisted on the ground that I am probably not the heir of my father.
What?
The plaintiff was not the heir of the father. Primarily on that ground, it was resisted, D1. And in the appeal, they choose not to appear. In fact, my lord, from one order, it will appear that the learned advocate, Mr. Shodhar, who was appearing for the respondent number 1, he has said that his clients do not want to proceed with the appeal or contest the appeal, my lord. There's an order.
No, then the substitution was affected. What about the yes?
Done. Done. My lord, take up page 96 of paper book.
Then let it go back.
My lord, may I say
Go
this?
back.
My lord, may I say this? My lord, may I say this? My lord, may I say this? May I say this, my lord? One does not choose to contest.
No, maybe, but his predecessor contested it.
Yes, but here he doesn't want to contest.
No,
There's an order to the effect as well. There's an order to the effect. And there's an instruction also on the record, my lord,
what?
that their clients do not want to contest.
No, contest the appeal.
Appeal.
And then say the appellate court let him decide what they will do.
But my lord,
That does not mean that they have chosen to consent for setting aside the judgment.
May I put it this way, my lord? If they choose not to contest the appeal,
That is an appeal.
yes,
Because they were a successful party,
yes,
left to the court, even if the party does not appear.
there's an instruction by the party which is already on record.
That contest what? The appeal,
The appeal,
not the suit.
the appeal is considered the suit
No.
of the list. Yes.
So
But now, if they choose not to contest, my lord, may I say this, my lord? And my lord, the parties who are not arraigned, my lord, the parties who are not arraigned, my lord, they are parties out here, 3 and 4.
so we are sending it back. Let the suit be decided.
But it will take time, my lord.
Now on a technical ground that they were not made party, now they have been arraigned as a party in the appeal. Now this thing has gone. Now the court has to decide on merit.
So the appellate court, my lord, and I'll tell
Why
you,
appellate court?
my lord, I'll say this, my lord.
Sorry.
None of the parties would object so far as the shares are concerned.
But that respondent number 1 is not coming.
Let me try once.
So
Let me try once.
none of the parties means he is a very much a party.
Yes.
So he
He
must
wants to
say,
defend number 1, he's respondent number 1.
he must say that I admit the share. Let him come and say I admit the share, no difficulty. If the other parties have admitted it, no problem. Difficult.
I understand what's going through my lord's mind, but my lord, in the case of remand, it will again prolong the issue, my lord.
No.
I understand, my lord, I understand. So, but let
He
me
may
take a chance.
later on choose not to contest.
Yes.
That is a different one in the trial court.
Court as well.
But if that being the position, they have been arraigned as a party. I do not know how, but has been done.
No. What has been done?
Addition.
Addition Delaware, just as what says. They were added by an order dated 18/1/2017.
I've seen that. That is before me.
It's because what we argued at that point of time was that this was a preliminary decree. Till the final decree, the suit is subsisting. So addition of parties could be permitted. So that is probably weighed in the.
Is it true that it is only dismissed on the ground of non-implement of this?
Yes.
Priti Kanada.
Yes.
Priti Kana Das. Priti Kana Das was not added as a party.
No.
He's a co-sharer.
Yes.
In fact, my lord would get it from.
The heirs are already on record.
Yes, my lord.
They have been brought on record.
Yes.
You are representing that set.
No,
Priti
Lordship,
Kana-
I am representing 2B to 2D.
That's
That
the
is,
Priti Kana.
no, Lordship,
No.
the original defendant number 2, Lordship.
Okay.
During his lifetime, Lordship, he executed a deed of gift in my favor.
So all other co-sharers are already a party.
Yes.
Is it true? We are believing your statement that
Yes.
the suit is dismissed also.
My lord, for my satisfaction, my lord kindly takes page 989 onwards.
এই পেপার বুকটা দাও একবার
89 onwards.
Yes.
কেন have you filed a paper book?
Yes, filed.
Yes.
Yesterday. Filed yesterday, my lord. 2 weeks was granted by the early order, my lord.
To us from
My lord,
The internal page number 10, Lordship,
of the
of the impute
judgment.
order,
Yes,
impute judgment, Lordship.
my lord,
May I read it for you, Lordship? Page 10, plaintiff preferred to proceed with the suit without impeding either Pritikona Das or her legal heirs in her absence as a
That was
party
the only-
defendant.
Yes, only on the ground.
Yes,
yes.
on that ground.
ঠিক আছে, রেখে দাও, ছেড়ে দাও। The instant appeal arises from
We come back, my lord, we come back next
not
Tuesday.
tomorrow, first day, because we can't finish it off within 5 minutes. To be mentioned first matter, do it tomorrow.
In that event, if my lord remands it with a time frame, my lord. With a time frame then. If my lord is harboring intentions of remanding the matter.
Whether the notice of appeal was served upon this.
No, 3 and 4. On 1, yes, but not on 3 and 4.
No. The heirs of Pritikana,
No, I checked out records.
then
That's the hobby.
Then-
That's why I was saying if I might try my luck, if I could get them to appear.
no, then we can't dispose of. Then we'll have to bring them.
Appeal is ready.
Hmm.
Kalki to be mentioned.
I'll do it, Mr. Lord. ওই করে কি দেখছো নাকি তুমি নাম দেখে নাও তুলে দাও